Hi, good afternoon. Welcome. We are going to discuss estate administration this afternoon, an exciting and very practical topic in the world of wills, trusts, and estates. I've posted for you online some corresponding PowerPoints that you can review while we work through this videotape. Now, to start off, what even is the purpose of estate administration? I would say first, an important purpose of estate administration is to collect the assets of the decedent, to collect and inventory the assets of the decedent. Another important purpose of estate administration is to pay all taxes and to pay all claims against the estate. And finally, after assets have been collected and inventoried, claims and debts have been paid, appropriate tax returns have been filed. From a 30,000-foot aerial view, if we're looking at the purposes of estate administration, next we would distribute whatever is left over to the heirs. Now, two questions to ask when determining whether or not probate as a process is even necessary. First, after you inventory and collect all assets, you want to consider or assess what assets are probate assets, because only probate assets have to go through the probate process. Second, you want to consider whether or not all of the probate assets even have to go through probate as a process. Not all probate assets need to go through probate. There may be in your state a statutory exception. By way of example, in many states there is something called a small estate exception or exemption, depending on the state that you are in. Generally, we see estates under a certain size being authorized to close outside of probate. What size? Well, it's usually a monetary figure that varies pretty dramatically from state to state. In the states that I have dealt with, $100,000 is not an uncommon number. In UPC 3-1201, an exemption from probate is provided for assets worth less than $100,000 that meet several other conditions. In the state of Nebraska, for estates or small estates with personal property, it may be possible to transfer that personal property outside of probate if certain requirements are met. What are those requirements? Fair market value of less than $50,000, 30 days or more have passed from the date of the decedent, and of course, no real property to be transferred. Also, in the state of Nebraska, you have section 30-24,127. This section provides that if the value of the property in the estate does not exceed allowances such as the homestead allowance or exempt property or funeral or burial expenses, the estate may be exempted from probate. It is also worth mentioning that in some states you have what is called a surviving spouse exception, where the estate can be administered outside of probate. In the states in which I have seen this exception, the size of this estate is not relevant. They will allow surviving spouse, if all property is left to surviving spouse, to be handled outside of probate. But in agreeing to do so, surviving spouse has to sign a document agreeing to liability if there are any unpaid claims against the estate. And for that reason, it is not uncommon to avoid using surviving spouse exception with larger estates because of unforeseen liabilities that could pop up. Now, the purposes of probate, let's talk about those next. Purposes of probate: to evidence transfer of title to new owners, also intended to protect creditors by requiring payment of debts, distributes decedent's property to the intended beneficiaries after creditors are paid. Probate property itself is property that passes under a will or vis-a-vis intestacy. The original copy of the probated will is usually stored indefinitely in the courthouse, though this does vary from jurisdiction to jurisdiction. Non-probate property is property where title transfers outside of probate. The term non-probate property and will substitute, the terms non-probate property and will substitute are frequently used interchangeably, though there is a nuanced difference between the two. Non-probate property as a term includes all property that is not probate property. That may include property that is not probate property because it has been accepted from probate, whereas a will substitute is a written instrument that passes on an economic benefit from one person to another person at the testator's death, and this benefit passes without a formal will. The written instrument can be a contract, a trust, a conveyance such as a deed. Title then passes to the beneficiary pursuant to that written instrument that creates the will substitute. What are common will substitutes? Joint tenancy property is an example. Joint tenancy with right of survivorship, where property passes automatically to a surviving joint tenant. Life insurance property is another example where the proceeds pass to the named beneficiary when the insured dies, and those proceeds need not go through the probate process. POD accounts, payable on death accounts, those are accounts where the proceeds or the amounts that have been deposited pass pursuant to the instrument that creates the account to the named beneficiary on the account. Totten trusts are basically a bank account opened by someone as trustee on behalf of a named beneficiary. And then you also have inter vivos trusts, sometimes called living trusts by the layperson. And property transfers with inter vivos trusts may take place upon the creation of the trust or may take place later. Now, will contests in the probate process, we have talked about will contests earlier in the semester, but because they're relevant to the probate process, I will briefly touch upon them again. Who may contest a will? The answer is any interested person may contest a will. So what makes you, quote unquote, interested? The answer is somebody is interested if they will benefit financially if this will is set aside. So beneficiaries under a prior will, for example, or next of kin as defined by the intestacy statute, perhaps the state if there's a question of escheat. Executors under a prior will may usually only contest an instrument to ensure that a beneficiary is not impaired by the probate of an invalid will. What about the spouse of a possible beneficiary? The answer is no. The spouse of a prospective heir or possible beneficiary does not have standing to file a will contest, even in a community property state. The creditors of a decedent may not file a will contest. Why is that? Because the creditors of the decedent are in the same position with regard to the rights that they have, whether we probate this will or we set the will aside. Can creditors of a beneficiary file a will contest? Let's talk about that. There's a difference between general creditors and judgment creditors, and it is generally agreed that the general creditors of a beneficiary may not file a will contest. There is a split of authority as concerns judgment creditors, but we will not cover that split in this class. Someone is interested for purposes of a will contest only if they will benefit from this will being set aside. And so it is important to note, for exam purposes, that a pretermitted heir is not an interested witness. A pretermitted heir receives the exact same statutory amount whether or not we set aside this instrument or we probate it. And so they are not a will contestant. Similarly, a no contest clause does not apply to the pretermitted heir. It's also worth mentioning briefly that the time in which one can file a will contest varies sometimes dramatically from jurisdiction to jurisdiction. The next topic, which is an extremely important topic that I want to cover with you, is exoneration of liens. Exoneration of liens, the minority position, which also happens to be the law in the state of Nebraska, is found in section 30-2347 of the code in Nebraska, is that specific gifts of property transfer subject to liens. That means that unless there is a specific directive to pay off a mortgage on a home, by way of example, that the home will pass subject to the mortgage. It is worth noting that general language stating that the executor should pay off any and all debts is not specific enough. Now, what is a specific gift of property? It is a gift of specifically identifiable property that the decedent owns at the time the will is executed, such as my house in Napa Valley or my red car. The issue of exoneration of liens is when there is debt attached to the specific gift of property. Do we transfer the specific gift of property subject to that debt, or do we pay it off prior to transferring it to the beneficiary? And as I'm sure you have surmised, there can be a great deal at stake in terms of the amount of value passing to the beneficiary based upon whether or not this lien is exonerated. The majority position, though it does seem to be shifting, there does seem to be a trend by which this position is shifting, is that the specific gift of property transfers without the lien or the debt attached, that it is paid off by the executor prior to transfer, and it is transferred to the beneficiary free and clear. An example on the PowerPoint for you: testator bequeaths to my son my home. The home is valued at $500,000. there is a mortgage on the home of $50,000. In the minority of jurisdictions and Nebraska, this home would be transferred subject to the $50,000 mortgage. In the majority, the $50,000 would be paid off and the home would be transferred free and clear of any encumbrances. It is very important to know what the decedent's intent is when you are drafting an instrument for the decedent as to whether or not they would like to be the property to be transferred subject to the debt or not, so that that can be properly articulated in the instrument, because this is something that you can indeed plan around. A personal representative. What is a personal representative? A personal representative is someone who is authorized by the court to administer the estate of the deceased. There are, in some jurisdictions, very common disqualifications to serving. As a PR, though these qualifications vary, or these disqualifications vary pretty dramatically from state to state, a common disqualification to serving is that one is not a U.S. resident. If one is a surviving partner of the decedent and an interested person objects to the appointment, in some states that will prevent you from serving. Other issues: lack of mental capacity, if someone is a minor, if someone has been convicted of a crime. Now, under this umbrella of personal representative, one may either be an administrator or an executor. An administrator is someone who is named to administer the estate who is not named in the will. So the will may fail to name someone, or the person named in the will may be deceased, or the testator has died intestate. There is a statutory list that the court goes through, and preference is generally given in a very normative order: surviving spouse, children, then testate beneficiaries. That is not an uncommon ordering. There's a bond requirement with an administrator. Sometimes it can be a rather hefty bond. The person who is appointed must give the bond. The bond is for the protection of those who are interested in the estate. The bond is intended to protect against losses from improper estate administration. In the alternative to an administrator, perhaps an executor has been named. When decedent dies testate and has named a personal representative, we call this person an executor. There are advantages to naming someone in your will. You have control over who manages your estate. You would hopefully appoint someone with appropriate expertise. You can, in the instrument, waive the bond requirement. You may name alternative executors, hopefully from different generations. You may specify the executor's powers, although this may not be a wise thing to do. It may be easier to generalize or liberalize the powers so that an executor need not seek permission every time he or she wants to do something, because getting court permission can be quite costly and it may just drain assets from the estate. In most states, the executor must give a bond unless it is specifically waived in the instrument. Even if the bond is specifically waived, this does not mean that the court is bound. The court may nonetheless insist that executor provides a bond. if the court feels that it is necessary for the protection of the estate. Both administrators and executors derive their authority or their power from court appointment. The authority only begins upon court appointment. The duties of the personal representative are to inventory and gather decedent's assets, as well as collect any payments owed to the decedent, to pay any bills and debts owed by the decedent as they come due, including preparing and filing taxes, and to distribute leftover assets with appropriate title transfers. The personal representative also has a duty to file all appropriate state and local returns for tax purposes and to pay any taxes due. It's also worth noting for you that this includes or may include estate tax. The estate tax return is a separate return from a federal income tax return. The statute requires that the personal representative, or statutes generally require that the personal representative provides an accounting at set intervals and or at the completion of the estate administration. The administrator or the executor is not required to do everything him or herself, meaning the executor or the administrator may hire a CPA to do the taxes for the estate, but it does fall upon the personal representative to supervise that delegation.